हेलो। कहाँ है कोट? हेलो। हेलो। नहीं है कोई ना। टेस्ट। हेलो। टेस्ट वन। हेलो हेलो।
may be fixed as to be mentioned on Friday or subject to convenience of the court.
Paper books are ready.
Yes, my
Events on Friday.
Diploma.
Events on Friday.
My lord.
Not in the list. Call the list.
My lord, item number 39, 40 and 41, my lord. Similar matter appeared before the court number 1 yesterday and it is fixed for hearing. I only pray that it may be released from this court.
Item number 39.
To 41, my lord.
Okay, please take down. The order. Sri Sabha. Sri Sabha. Learned advocate appearing on behalf of the petitioner submits that the similar matter is appearing before the learned first bench. So this matter may be released from the list. On submission of the learned advocate for the petitioner, the matter is released from the list on this court. For listing the same for the learned first bench.
My lord, I am grateful, ma'am.
There were 3 learned first bench. Honorable first bench. Not allowed. Honorable first bench. 39, 40 and 40. Item number on.
Well, this matter my senior is appearing. He is left before court number 1. I pray for Friday. Well, this matter.
Friday.
I appeal for the state.
Lordship, I am for respondent number 2.
Yes.
Order of honorable family judge is in challenge. What I pray is, Jaipal sir is court number 1. Let it be passed over. If he comes, then we will plead order to be fixed for Friday.
Friday at the top of the list. Friday
Friday is not ready to do this matter today.
Yes, sir.
Lordship,
Lordship, on Friday top of the list.
Okay, on the prayer of the district. On the prayer of the learned advocate for the petitioner. The matter is adjourned today, release the matter on Friday, that is
13.
at the same list, at the same position.
Oblige, beautiful.
Item number 2.
I appeal for the state.
My lord, in this matter, my senior Mr. Rakesh Palgovin is appearing for the petitioner, my lord. Let the matter may be listed tomorrow, my lord. He's keeping unwell.
This is parted matter, I think.
Part heard matter.
Yes, yeah.
This is
My,
Srimati Rupala.
Rupala. That's splitting up the case.
Yes,
my lord,
I think the case.
certain citations have
Yes,
to be
some
placed.
authority has to be.
Yes, yes. So in that event, I pray for Monday because even I want to look for certain citations. Because yesterday I've seen splitting up has been done in various cases in those the accused are absconding and all. I didn't find it aptly on the point of charge. So therefore, I need some time to go through and then I'll also file a citation. Monday.
Okay. Please take down. On the prayer of the petitioner, the matter is adjourned to this the matter on 16th
16.
of further days. Yes. Item number 3. CRA on of 2022.
Here I appear for the state. It is an appeal of the state against acquittal. The other side, I don't know whether he is appearing or not. The service was effected through registry.
No, it's not. Okay, paper book is ready.
Yes, yes.
So which for the
Nobody has entered appearance so far for the accused person, alleged accused, because
okay, respondent has not taken the paper book also.
so notice is to be served upon him. On the last occasion, there was a direction upon the registry to serve.
have to be evicted to the court. Yet. Where is the copy? Copy of notice. Notice has been served and it was received. Receipt served. It is served and received. This is the notice. This notice it is received.
This is the police constable. Because I have served the notice through the concerned PS. So the police constable has received it and he was directed to serve. Down below it is written PC.
Okay, PC. That means it was not served until today.
Not served.
No, you were directed to serve on the last occasion by the circuit bench on September 18th.
September 8th. I have taken step, Your Honor, so through SHO I have served it, but the SHO has not delivered, I will. So let it be taken up on next week so that I will find out.
Okay. To take report, okay?
Right.
Mrs. A. Jinnu, Ms. A. Jinnu, Planet Advocate representing the state. Stroke applicant. Shall take proper report from the concerned SH regarding the fate of service of notice upon the respondent. And the inform the court to that effect. The next week, release the matter on the next week on 17th.
17th.
Release the matter on 17th. Yes. Item number 4, CRA SB 5 of 2022.
I pay for the state.
My lord, I appear for the appellant hearing, my lord.
You know, Your Lordship.
My lord, this is an appeal challenging the order of conviction passed by the learned additional session judge of Mayabandhan on 23rd day of September 2022.
Only please. Your Lordship, can it be taken up on Friday?
My
Because
lord, I'll start my arguments. I'll finish it off. Let madam argue on Friday.
Yes, that can be done.
that-
Okay.
Let
Otherwise,
madam
we
argue.
take the Friday, then it
Yes,
cannot be
then
complicated.
because 20th, I don't think there is a working day, 20th. 20 तारीख से छुट्टी है। So 20th happens to be Friday. So we'll be left with only 4 or 5 days.
Yes, you start.
I'll start. Here, my lord. The appellant herein was convicted and was sentenced to suffer
7 years.
7 years of RA and was also sentenced to pay a fine of rupees 50,000
Yes,
on an allegation of an offence under section 20B 2B. That is, the accused person was caught, the convict was caught with the possession of intermediate quantity of contraband totaling to 15.5 kgs. Now, my lord, in order to establish the case of the prosecution herein has examined altogether 9 witnesses. The first witness happens to be the complainant. Now, my lord, I'll just give the brief facts of the case first. The facts is like this, that on 25th of October 2019,
yes,
secret credible information was received by PW1, that is Sumen Kumar Haldar. Based on such secret information, a raiding team was formed and a raid was conducted in the evening hours after the sunset, and the seizure memo would reflect the timings. It was at 17:55 hours, 17:20 hours. It's at page number 30, my lord. Page number 30 may kindly be seen.
30.
Yes, 30.
Yes,
The seizure memo was there, and it indicates that the seizure was effected at 19:20 hours.
yes,
That is after the sunset. My lord, the seizure was effected at Mayabandar Jetty Gate. May I just read it, my lord?
yes,
Now I'll come to the evidence straight away at page number 2, PW1, my lord. I am now posted at District Court, North and Middle Andaman, Mayabandar as GRO on 25/10/2019. That is on the day of seizure. I was posted at Mayabandar PS in charge. On that day, I got information from reliable sources that one ship, namely MV Swarajdeep, came at Mayabandar with illicit ganja on 18/10/2019. That is, the ship arrived on 18/10/2019, but the information was gathered on 25/10/19. I came to learn that Ashok Biswas is the accused person.
yes,
Ashok Biswas brought the same, and description of the contents was also received. The description was white sack with totem mark. Ashok Biswas on 25/10/2019 tried to clear the same and took the same to the other place. I received the information at 12 noon. Receiving the information, I informed my senior SDPO, namely Shri Hukmaram, and as per his direction, I prepared a notice under section 42 of NDPS Act. Now, my lord knows that in any NDPS case, if a secret information is received, the same has to be reduced in writing, which is mandatory. Here, this thing was not done. Now, the witness himself says that he has prepared a notice under section 42 on whose direction? On the basis of the direction of his own superior officer, that is SDPO.
Yes.
That means this particular notice under section 42 cannot be treated as the secret source information. Now, my lord, thereafter, this is the said notice prepared and signed by me. Let it be marked as Exhibit 1. Now, my lord, may kindly come to Exhibit 1 first. Now, my lord, here he says that this notice was prepared on the basis of the direction given by his superior authority, and he has forwarded it to his superior authority. So this by any stretch of imagination cannot be treated as a secret information, because the moment an officer in charge of the particular police station receives the secret information, it is bound in duty to record such information in the general diary by giving a specific general diary number.
Yes.
And section 42 also says that if an officer receives a secret information, it has to be reduced in writing, and such copy of secret information has to be immediately forwarded to his superior officer. This is what the mandate of section 42 says. First thing, he has to reduce the same in writing, and the thing what he has reduced, a copy of the same has to be forwarded to his immediate superior officer, which has not been done in this case.
Yes.
Because admittedly section 42 notice was prepared as per the direction of the SDPO. SDPO has not received the information. Now, my lord, let this notice, this is the said notice prepared and signed by me. Let it be marked as Exhibit 1. The notice is sent to SDPO Diglipur for necessary action. SDPO Diglipur also stated to me that he would be available for raiding team. At about 6 p.m., SDPO came to Mayabandar. I called two independent witnesses, namely Kurma Rao, so-and-so, and Shyamlal, along with the and PS and staff of PSCCS, along with the weighing machine, and two independent witnesses with the raiding team. Lord, the incident has taken place at Mayabandar. We have got police station of PSCCS at Port Blair.
Yes.
I don't understand as to from where the opportunity could be gathered by this complainant to say that staff of PSCCS Port Blair were summoned to come along with the weighing machine. Because it's not a case of PSCCS. It's a case of PS Mayabandar. Now kindly see what he says. Staff of PSCCS Port Blair along with the weighing machine and two independent witnesses with the raiding team has been to Mayabandar Jetty, SDPO. Diglipur also reached there. The raiding team was scattered outside of Mayabandar Jetty. One person was coming to Mayabandar Jetty with the white color sack in his head. Seeing the police, he tried to return back. The police stopped him and thereafter told him that there is an information relating to transmission of ganja from Calcutta from reliable sources. I asked him for a personal search. My lord, this is very important. I asked him for a personal search.
Yes.
But he denied to do so. And thereafter, a notice under section 50 of the NDPS Act was served upon the said person in the presence of the SDPO. Signature of the SDPO is also depicted. This is the said notice. Let it be marked as Exhibit 2. Then thereafter, after searching the said bag was done in the presence of independent witnesses under the seizure list. The bag, it should be bag, I believe, Your Honor. Sag. The said sag was opened, and from the said sag, but this here we need to give an importance. From the said sag, one fishing net was found, and from which two small packets were found. The said packet was opened, and from which ganja was found, and it was weighed through weighing machine. The measurement was 10 kg in one packet and 5 kg in another packet. Inside the packet, name of Ashok Biswas was found. Then ganja was seized and under the seizure list. And this is the such seizure list. Now, my lord, he was deferred. Subsequently, again, examination in chief was conducted, and thereafter, my lord, certain things were exhibited. One packet is shown to the witness. This is the said packet. Packet is open. These are the said leaves of cannabis. The packets containing leaves are marked so and so, so and so. Another seal packet is shown to the witness. The packet is open. These are also leaves of cannabis. The seal packet is shown to the witness. The packet containing leaves are marked as Mat Exhibit 2. The packet labeled in the presence of the witnesses. Signatures were there. Then this is the packet where the fishing net were found. This is the such fishing net. Then same was sealed and labeled. The packet was labeled in the presence of witnesses. He arrested the accused Ashok Biswas and produced him to the police station. After that, I submitted the report to the SHO of PS Mayabandar. I chalked out this affair. This is the said report. This is marked as Exhibit 4. I filled up the form. This is the said formal affair. It is marked as Exhibit 5. The investigation officer seized the brass seal under the seizure list, wherein I signed. Now, my lord, first of all, the mandatory provision of compliance of reducing the secret information in writing, that was not done. The written secret information which was there in the GD, that was not forwarded to his immediate superior officer. And admittedly, from the seizure list, we can very well come to a conclusion that the seizure was effected in between sunset and before sunrise. And if this, my lord knows that if the seizure is effected after sunset and before sunrise, then it is mandatory upon the officer conducting the raid to have either the authorization search warrant. If he is not having that search warrant, then he will have to give the reason as to what prevented him from not obtaining such search warrant.
Yes.
These all things have not been complied with, which are mandatory provision. Section 42. First, he has neither reduced the same in writing, the secret information,
Yes.
nor forwarded it to his immediate superior officer in writing. Nor he was having a search warrant, because the raid was conducted after the sunset and before the sunrise.
Yes.
And the reason that he was not carrying a search warrant, for that he has not given any explanation, which is mandated in terms of section 40. I will produce the citation one by one. Now, my lord, what will be the applicability of section 50? Because if my lord may kindly come to section 50, notice under section 50 may kindly be seen. Yes, ma'am. May I just come here, my lord?
Page.
It's at page number 29.
Yes.
My lord, so far as section 50 notice is concerned, that will be applicable in case of a personal search. If personal search is not done, and if only the baggage is searched, then the applicability of section 50 will not be there. But in our case, how we will have to correlate and how we can find that whether the notice was given for a personal search or not, that has to be seen. Now, my lord may kindly come to page number 29, that is the notice. My lord, on the very top, it has been written that where there is a reason to believe that you are in possession of narcotic drugs, psychotropic substance, oblique controlled substances. They are not clear as to whether the articles which they have an information was a ganja. If it is a ganja, it will definitely not be a psychotropic substance, nor it will be a controlled substance. It will only be a narcotic substance, which is a natural product.
Yes,
Because psychotropic substance says that it should be a chemical product.
yes.
But they are not clear. They are given three options. Therefore, we would like to conduct your personal as well as, here it is very important, my lord. Therefore, we would like to conduct your personal as well as your belonging search, and a gazetted officer is also presented with us. If required, such will be conducted if required. My lord, here I am giving a stress that if required, such will be conducted in presence of him. It is your legal right to search the police personnel and the witnesses before search. My lord, if we go by this, it indicates that the notice was issued for the personal search and subsequently thereafter for the search of the bag. Now, my lord may kindly come to the evidence of PW2, whether the personal search was conducted or not. I'll just, thereafter again I'll come to PW1, my lord. May I just point out the relevant portion, my lord?
Yes.
My lord, examination in chief of PW2, first paragraph, last two sentences. First paragraph. SAMANTA, that is the complainant. SAMANTA detained him and SAMANTA stated for checking him. If it is for checking him, and if the notice indicates that for conducting his personal search, that means the personal search was conducted and thereafter the belongings were searched. If these two things are correlated, it can very well be said that the applicability of section 50 is there, because there are curtain of judgment which says that if the personal search is not conducted and if only directly the baggage or the vehicle is searched, then the applicability will not be there. But if after conducting the personal search, thereafter if the baggage are searched, then the applicability of section 50 will be there. Now, in this case, I say that by going through their own notice, it has been specifically mentioned to conduct your personal as well as the belonging search. That means the applicability will be there.
Yes.
Now, if applicability is there, then in that event, we will have to see whether they have complied with the provisions of section 50. Now, section 50, the act says that it is mandate on the part of the officer receiving the secret information to inform the accused about his legal rights. This terminology has to be there. The accused person has to be apprised with his legal rights of being searched in the presence of nearest magistrate or a gazetted officer.
Yes.
This is what section 50 says. Now, kindly come to this particular notice. They have left all these things. There is only one more option. Now, my lord, may kindly again come to the notice.
Yes.
Now, whether these two options were given to the accused or not, kindly see. Whereas there is a reason to believe that you are in possession of narcotic, psychotropic controlled substance. Therefore, we would like to conduct your personal as well as your belonging search, and a gazetted officer is also present with us. If required, such search will be conducted in presence of him. So there is no option given to the accused to the effect that his search can be conducted in presence of nearest magistrate or nearest gazetted officer. There are judgments. They have said that the legal right was apprised with regard to what? Legal right to search the police personnel and the witnesses before the personal search. There is no provision of having a legal right. Section 50 does not mandate that accused should be apprised of a legal right to search the police personnel. Accused should be apprised of his rights to be searched in the presence of nearest magistrate or gazetted officer.
Yes.
This is what section 50 says. So they have totally flouted this particular thing. So there is total non-compliance of
Section 50.
section 50 of NDPS Act.
Yes.
Now, my lord, in the notice, there has to be a specific refusal by the accused to exercise his legal rights. Until unless there is a specific refusal, the option of the accused person of being searched in the presence of the officer, another officer who is a gazetted officer of the police department, will not be there. Now here he has never stated, there is no reflection indicating that the accused person has refused to exercise his legal rights of being searched in presence of the nearest magistrate or gazetted officer. Kindly see in the last portion, there is one particular statement that goes to say that I have been informed and I have understood the notice under section 50 of NDPS Act, and I agree and allow you to search myself as well as my belongings. Here again he says, I'll allow you to search myself and my belongings. That means personal search was done and thereafter the belongings was done.
Yes.
Then if these two things are done, then the applicability of section 50 is there. And if the applicability of section 50 is there, then it has to be complied in a proper sense. Now, my lord, may kindly come to PW2, my lord. I am now posted at PSCCS Port Blair as a head constable. On 25/10/2019, I was attached at PS Mayabandar. On that day, ICPS Somen Kumar Haldar told me that there is an information of cannabis which is coming through a container stationed at Mayabandar Jetty. One Ashok Biswas went to carry the said cannabis and wanted to proceed to Diglipur. At that time, two independent witnesses reached there and they were briefly informed the information, and I proceeded with the police team along with the independent witnesses to Mayabandar Jetty along with the investigation kits and the weighing machine. DSP Hukma Ram reached there after some time. After some time, I noticed Ashok was coming from inside the jetty with sacks. Seeing the police party, Ashok Biswas moved to the opposite side. SHO sir detained him, stated him the information relating to ganja, and thereafter notice under section 50 was served to him. On opening the sack, fishing net was found. Inside the fishing net, 2 bags were found. Now, my lord, here I'll pause this quote for a moment. On opening in the bag, 10.2 kgs of cannabis, and in another bag, 5.3 kgs of cannabis were found. Now, my lord, may kindly come to the evidence of PW1.
10 kg and 5 kg.
Oh, my lord, I think I have missed.
Yes, it's not there.
No. I think I have read.
Reading something else.
No, my lord, I'm coming to evidence of PW2, my lord, first. Let us come to PW2. I have by mistakenly I have read PW4. Let us come to PW4 itself, my lord. Let us come to PW4. PW4.
Yes.
Now, first examination in chief, last 3 lines.
Yes.
In one bag, 10 kgs to 10.2 kgs. That means 10 kg, 200 grams. And next bag, 5 kg, 5.3 means 5 kg, 300 grams. Now, what PW1 says? He has said the measurement was 10 kg and 5 kg. He is the complainant, my lord. He should be very specific with regard to the contraband articles.
Yes.
Now, my lord, may kindly come to the cross-examination of PW1. In the police station, GD register is maintained and it is running from 8 AM to 8 PM. Page number 4, my lord. I received the information in the capacity of the police officer. After getting the information, I had lost the GD and it was informed to my superior. Thereafter, notice under section 42 was served. The time of lodging of GD is 12 noon. I received the information at that time. Now, here, my lord, thereafter, I have not seen the extract copy of the GD during the course of my examination in chief. We are pointing out the secret information that was reduced in writing in the general diary. Whether you have seen it? No. I have not seen the extract copy of the GD in the course of my examination in chief. No documents was placed before me at the time of examination in chief that I informed the matter to the SDPO. The said GD copy, my lord. Not a fact that I received, not a fact, not a fact. The rest all will be in a not a fact fashion, my lord. Now kindly come to the evidence of PW2. He is the independent witness, my lord, before whom the seizure was effected. May I just read it, my lord?
Yes.
The incident took place at 25/10/2019 at Mayabandar Jetty. I received the phone call from PS Mayabandar at 4:30 PM. One Somen Haldar SI called me at police station. I saw the PS, that one Shamlal, another independent witnesses, was already there. I asked Somen. He stated to me that there is a information of cannabis, and for that reason I should have to go to Mayabandar Jetty. I went to Mayabandar Jetty along with the police team. Outside the gate of the jetty, we assembled. After some time, one person was coming inside the jetty to outside, from inside the jetty to outside with a sack, and seeing the police, he tried to move in the opposite direction. Somen sir detained him. Somen sir also stated for checking him, and notice was served. I signed in the notice. This is my signature. The sack was opened, one fishing net, 2 white color boxes were found. But here he gives another version that there were 2 white color boxes, those were found. Whereas if we read the evidence of PW1 at paragraph 4, he says that after searching the said bag, said sack was done in presence of the independent witness and seizure list. The sack was opened, and from the sack, one fishing net was found, and from which 2 small packets were found. Now, if we read the evidence of this particular witness, paragraph 2, at page number 6, examination chief, the sack was opened and the fishing net, and 2 white color boxes were found. This witness does not say about the presence of any kind of white color box. Now, thereafter, the articles were sent to the police station. I did not sign any paper, and thereafter I identified the articles. These are the said articles which were seen in jetty. I know the person from whom the articles were seized. Now, my lord, here there are certain things. What this witness has failed to say. First thing, whether the first he is inventing 2 new things. That is, 2 white color boxes were there. Now, this witness also does not say as to what were those articles, those were present inside the box.
Yes.
He has not stated anything. Then he says that the boxes were taken away. So that means he has not seen something being opened. The contraband was, kindly, again I am reading for the sake of convenience. The sack was opened and the fishing net, and 2 white color box was found. Thereafter, the said articles were sent to the police station. Now he is totally silent with regard to the presence of cannabis inside the bag, and rather he is telling that he has found 2 white color boxes. Now, my lord, he has not said that whether any seizure list was prepared, whether the articles were sealed. The process of sealing of the contraband articles before the independent witness is a mandatory duty of the IU.
Yes.
Now, my lord, he has not said that he has found the bag containing fishing nets, nor he has said that there was some cannabis. He has only said that he has found 2 white boxes which were sent. Now he is also admitting that he is also saying, now here the witness was never declared hostile by the prosecution. Whatever his version was there, they have given a clean chit to him. Now he has said that I did not sign any paper thereafter. That means he has not signed any seizure list. Now, my lord, may kindly come to the next page, page number 7. I signed in police papers sitting at PS at about 7:30 PM. Now, my lord, the seizure was effected at 7:20. He has signed it at 7:30 at PS. Now, from where we will gather the distance of PO to the police station, it will be reflected at page number 33. My lord, got it? Page number 33 is the FAR. And point number 5 will indicate the place of occurrence, direction and distance. It is 5 kilometers. My lord, got it?
Yes.
Yes. Page number 33, point number 5, the distance 5 km. Now, my lord, next witness. He is another witness of seizure.
PW3.
PW3, my lord, independent witness. The incident took place on 25/10/2019 at Mayabandar Jetty. I received a phone call from PS Mayabandar at about 4:30 PM. On reaching police station, police stated to me that I have to go to Mayabandar Jetty as some illegal materials came, and also for searching the same. I went to Mayabandar Jetty with my bike. Police identified one person from whose possession cannabis were recovered. The said cannabis were kept inside the plastic bag. Now he is giving the third version. He is leaving the sack. He is leaving the fishing net. He is leaving the white color box, 2 boxes. Now he says that it was kept inside the plastic bag. Thereafter, the said plastic bags were opened and seized at the place. I signed the seizure list. This is my signature on the seizure list. That after sealing the seized articles, the said person was arrested and police took him. I know the said person. His name is Ashok Vishwas. Now, my lord, these two witnesses, PW2 and PW3, has nowhere stated that when the accused person was intervened, at that time, the officer in charge has served him any notice under section 50.
Yes.
Neither PW2 has said, nor PW3 has said. The PW2 has said, he has notice was served, but PW3 has not said that he was served with any notice. Now, the most important part is neither PW2 nor PW3 has stated during his examination in chief that there was one SDPO who was a gazetted officer who was present at the time of conducting the seizure.
Yes.
Now, my lord, may kindly come to evidence of. Now, these two witnesses, PW2 and PW3, have also not stated that the cannabis were weighed, and the weight of each cannabis in one bag it was 10.2 kgs, and in another bag it was 5.3 kgs. These two witnesses have never stated anything with regard to even to the weight.
Regarding the weight also, they have not.
They have not stated anything.
Or whether it was measured or.
No. They have, first of all, they will have to say the weight. Then only they will come to the point that it was measured and then it was weighed. They have neither said that it was measured, nor was it said that it was weighing 10 kg and 5 kg.
Yes.
Now, my lord, the person, that is PW1, who is stated to have served the notice of section 50 to the accused person, he has also not said in his entire examination in chief that the accused person was given or was apprised of his legal rights of being searched. He has not stated anything. He has only said that yes, we have issued a notice, conducted the personal search, bag, everything. Now, my lord, PW4, he is a head constable who was a part of a raiding team. I am now posted at PSCCS Fort Blair at head constable. On 25/10/2019, I was attached at PS Mayabandar. On that day, ICPS Somen Kumar Haldar told me that there is an information of cannabis which is coming through a container stationed at so and so, and one Ashok Biswas went to carry the said cannabis and wanted to proceed to Diglipur. At that time, two independent witnesses reached there. And they were briefly informed the information. I proceeded with the police team to along with the independent witnesses to Mayabandar Jetty, along with the investigation kits and weighing machine. DYSP sir, Hukmaram reached there after some times. After some time, I noticed Ashok Biswas was coming from inside the jetty with sack. Seeing the police party, Ashok Biswas moved on the opposite side. SHO sir detained him and stated to him information relating to ganja, and thereafter a notice under section 50 of NDPS Act was served upon him. On opening the said sack, fishing net was found. Inside the fishing net, 2 bags were found. One bag contained 10.2 kgs cannabis, another 5.3 kgs of cannabis was found. It was seized under the seizure list, and the said Ashok Biswas was arrested and produced him to PS with the seized articles. Now, my lord, here this particular person has given the indication of 10.2 kgs of cannabis and 5.3 kgs of cannabis,
Yes.
which is different from the version of the complainant, that is PW1. Number PW5, who is at page number 12. He is the person who is said to be the person who has received the incriminating articles and handed it over to the IU. Now, I am now posted at PS Police Headquarters, Port Blair at Head Constable on 5/2/2020. I was posted at Mayabandar PSS Head Constable. On that day, I received an information from SP office that one article was brought to SP office which are to be taken, and I received the same and handed it over to the IU. Now, my lord, one article means which article? First thing, whether it was anything relating to a weapon of offense, whether it was relating to a cannabis, or whether it was relating to any other wearing apparels or any other articles. He has not reflected anything. He has only said that on that day I received an information from SP office that one article was brought at SP office which are to be taken, and I received the same and handed over to the IU. Now, my lord, those articles what he has brought, the witness has to be very specific.
Yes.
Indicating that he has received such and such article in connection with such and such FIR. So merely vaguely submitting that he has received an information to get one article and then handed over to the IU, he has not stated anything regarding that. Who is the IU? Who is the SP? What is the article? In connection to which case this was received? Nothing has been said by him. So this witness will not play a vital role. Let me then come to page number 13. Now, my lord, here he says that in his presence, the brass seal and the notice under section 50 of NDPS Act was seized by the IU.
Yes.
My lord, it should be the bounden duty of the witness to say as to from whom the same was seized. He can say that yes, it was seized, but from whose possession it was seized, that has to be indicated, which the witnesses failed to say, that it was recovered from, it was seized from Mr. Somen, that is PW1. He has not said anything. He has said that it was seized by the IO, but from whose possession
Yes.
and at what time and which place it was seized, there is no reflection to that effect. My lord, if we go by this particular seizure list, that is Exhibit 6/1, my lord, may kindly come to page number 37. It would go to say that the seals, those were used for the purpose of sealing, were never handed over to any of the independent witnesses, and it kept lying with the complainant. Whereas the law mandates that immediately after the seizure is effected, the seals, those were used for the purpose of sealing, has to be immediately handed over to the independent witnesses, so that it can be presumed that the seized articles were not tampered and it was foolproof. And thereafter, the recovery of those seals from the independent witnesses will only have to be done after the seized articles are sent to the CFSL.
Yes.
Till that time, it should be kept in the possession of the independent witnesses and not the police officer. Whereas here, from the seizure list, it can be very well be understood that it was lying first in the hands of the complainant, and on the very same day it was seized. That means the IO had the possession. IO of this particular case had the possession of the seals on the very same day. Now, my lord, PW 7. Now I am posted at PS Police Line Port Blair as constable. On 25/10/2019, I was posted at PS Mayadwand in the same capacity. On that day, one NDPS case was registered and I was on duty at PS. SI Anbeshwaran was the IO of the case. He searched the accused and a notice was received from his pocket of the accused, and the same was seized on the seizure list. This is the said accused. Not he is with regard to the seizure of the notice under section 50, which was served upon the accused person. Now, my lord, finally, the last witness would be the IO of this case. My lord, the IO plays a very vital and important role. My lord, if my lord just go through the examination in chief, I can bring out what are the things which he ought to have had done, which was not done. Now I am posted at SO IGP Law and Order on 25/10/2019. I was posted at Mayabandar PS in the same capacity. On that day, one affair bearing so and so was endorsed for investigation. I took up the charge of the investigation. During investigation, I seized one bracelet and a copy of a notice under the seizure list. This is the said seizure list which I prepared. Now, I also seized one original notice from the accused. I visited the PO, prepared the site plan. I examined the available witness, recorded their statements. Then thereafter, I arranged, my lord, this is very important. Paragraph 4 may kindly be seen, my lord. I arranged for obtaining sampling certificate from the land magistrate, and I collected the certificate. This is the certificate marked as Exhibit 9. Then I sent the seized exhibit to the FSL Port Blair. I received the report. This is the said report. I collected the CDRs, so and so, so and so. My lord, here, Exhibit 9 may kindly be seen, my lord. My lord, this is Exhibit 9 at page number 40, my lord. Now here I would say that there is a sheer non-compliance of section 52A of NDPS Act. That means the IO, before subjecting the seized article, will have to prepare an inventory
Yes,
indicating the origin of the contraband articles, the quality of contraband articles, the quantity of contraband articles. And he has to send that particular inventory along with the seized articles to the magistrate. The magistrate will then do the process of sampling, and he will then compare with that particular inventory that was given to him. And thereafter, he will issue a certificate in terms of section 52A, certifying the correctness of that inventory that was prepared by the concerned IO. Here, he has not stated anywhere that he has prepared the inventory. He has only said that he has obtained the certificate from the magistrate. Mere exhibiting, if I say that if the IO comes and says that this is the certificate, this is the thing, it will not automatically go. He will have to say, he cannot just simply say that yes, this is the seizure list. He will have to say that yes, I went to the spot, I seized the same, I sealed the same, I prepared the seizure list, and then this is the seizure list. Without giving all these formalities, if directly anything is exhibited, simply by saying that yes, this is the seizure list, it will not have the evidentiary value. The duty that is casted upon the complainant, the IO of this case, was to prepare the inventory of the seized articles. He has never stated in his entire examination in chief that he has prepared the inventory, and he has forwarded such inventory along with the seized articles and then obtained the certificate, which is mandatory. And this is the mandatory provision. Merely exhibiting a documentary will not become a proof.
yes,
Now, my lord, now this is the thing. Now here, the prosecution has also got one particular document exhibited, that is Exhibit 10. Exhibit 10 is at page number 45. That is FSL report.
yes,
Now, my lord, it was a FSL report with regard to the contraband articles. Now, my lord, it says at column number A2 that the A2 and B2. A2 and B2, my lord, has got it. There is the weight of the contraband article that was received. That is 21.515 grams. First. And secondly, 22.18 grams. Now, if we compare with the certificate that is at Exhibit P, Exhibit the page number 42, it has said that 220 gram samples have been drawn. At column number 5. Page number 42, my lord.
yes,
220 grams sample have been drawn, whereas they have received 21.515 gram and 22.018 gram. I can understand if the weight gets down, we can say that the cannabis got dried and the water contents got evaporated, and as the result of which the weight got low, the weight became less. But if the weight becomes more, then there will be a serious doubt as to whether the samples those were taken in presence of the magistrate, whether that was sent to the FSL or not.
Yes.
Now, my lord, now exhibit P10 that is appearing at page number 45 has been marked through the IO of this case, and the CFSL expert was never brought. The FSL expert was never examined before this honorable court, before the learned trial court, for exhibiting the same. And it was exhibited through the IO. Whether this particular document will so moto go, because a person will have to come within the purview of Section 93 of Indian Evidence Act for the purpose to get it automatically exhibited. The CFSL expert, the FSL, he is not CFSL, Miller, he is FSL expert. There is a vast difference between Central Forensic Scientific Laboratory and Forensic Scientific Laboratory and a central government. Now, he is an FSL expert who was never brought forward. Now, the IO has failed to comply with the mandatory provision, that is, he has not complied with Section 52A, he has not prepared an inventory, he has not sent the inventory before the magistrate to obtain the correctness of those certificates. Then the prosecution has not chosen to produce the CFSL expert, and apart from that, Miller, the gazetted officer. The gazetted officer who was present at the spot, he was also not cited as a witness, nor he was examined.
Yes.
Now, my lord, so far as the CFSL expert is concerned, my lord, I'll just place this particular judgment, my lord. 1995 CRLJ 1623, my lord. Expert evidence, admissibility, senior scientific assistant chemistry, TFSL, though not falling within the categories mentioned in it, but is an expert in science, his opinion would be relevant piece of in view of so and so, so and so. Report of CFSL expert admitted in evidence without objection during the word. Same cannot be objected at a later stage. Now, my lord, this was overruled. These two observations were overruled. Amarjit Singh and others versus the state. Now, my lord, may kindly come to page number 1628, my lord. 1628. Report of the CFSL expert has been tendered in evidence in the present case without any objection being raised regarding the mode of its proof and the
Referring
expert,
Paragraph.
paragraph 17, my lord. Report of the CFSL expert, exhibit PA, has been tendered in evidence in the present case without any objection being raised regarding the mode of its proof, and the expert was not called in witness for proving the contents of the said report. The contention raised by the learned counsel for the appellant is that the expert who has given the report does not fall within the category of section 293. Reports of certain, now my lord, what section 293 says, it has been reflected here. Now here, the report was given by the P.L. Bansal, Senior Scientific Assistant, Chemistry, CFSL, and not, the said officer is not designated as chemical examiner or assistant chemical examiner to the government. The reports of certain officers of the CFSL have been made admissible in evidence without experts being examined in clause E referred above. They are the director, the deputy director, or the assistant director. Shri Bansal is not shown to be any one of them. It is hence evident that section 293 was not applicable to this part. My lord, next paragraph, paragraph 19, my lord. Under section 45 of Indian Evidence Act, an opinion of an expert or a science is relevant piece of evidence. Shri Bansal, although not falling under section so and so, quote, yet he is an expert in science, being a senior scientific in chemistry. His opinion would be relevant in view of section 45. It is to be emphasized that here that this is a report, exhibit PA was allowed to be tendered in evidence without any objection being raised by the defense with regard to the mode of proof. In such situation, the question arises when a particular document has been allowed to be proved and exhibited without objection being raised by the defense, can the court entertain any such objection regarding mode of proof at any later stage? We are of the view that such an objection ought to be raised by the defense at the time the document sought to be tendered in the evidence, and such objection regarding the mode of proof cannot be allowed at the later stage. In case of Akbar Singh, an argument was raised on behalf of the state that once a document has been allowed to be tendered in evidence without an objection regarding mode of proof, then such a document cannot be rejected as being not proved by calling an expert to prove the same at the later. Reliance was placed so and so, so and so. My lord, now Milord may kindly come to paragraph 21. However, in case of Phul Kumar, the law laid down is that if the report has been accepted without objection regarding the mode of the proof, it cannot be objected at a later stage. The ratio laid down by the Supreme Court in consonance with the ratio of earlier PC so and so, so and so. The Calcutta High Court and Madras High Court and Orissa High Court have also taken the similar view in the cases of so and so, so and so. Now, my lord, these judgments were not brought to the notice of the court in case of Akbar Singh. The learned counsels of the appellants, however, sought some support from the observations made in para 30 in case of Chamanlal versus State of Punjab. The appellant cannot rely on exhibit DB to establish good faith in writing letters so and so, so and so. My lord, I'll place all the relevant judgments tomorrow with regard to non-compliance of those mandatory provisions, section 50, then 52A, then 42, 55, 57.
Yes.
I'll place those judgments tomorrow, my lord. And I'll close my arguments tomorrow.
I just want that at least one grace day may be given to me. If it is fixed on Monday, it would have been nice because even I'll come with certain judgments. Because the cross-examination part, my learned brother has not read
Let
it.
him conclude.
I'll conclude
If
tomorrow.
conclude
Thereafter,
it,
madam may take time.
Thereafter, I will take time because I need to, it's a transferred brief. So I was not prepared for it. However, I have noted the important key points, whatever my learned brother has stated. So I'll be confining my argument to that effect only.
Okay, please take down. The argument on behalf of the applicant heard in part. Let the matter be fixed tomorrow for further. Item number 5. POPPF 2023.
My lord, in this matter, I am appearing for the petitioner, my lord, an innocuous prayer, my lord. Because it's a partition suit, my lord, I had obtained the preliminary decree in the year 2016. 2017,
2000.
16.
Okay,
And in the year 2060 days time was given, parties did not come. So I had filed an application under order 26 rule 13. In 2017, it got allowed. 2000 rupees I had paid. Since 2017 to till date, the case is fixed for report of the partition commissioner and the case is not being proceeded. Till date, the Tahsildar Port Blair Tahsil has not submitted the report and it is being continuous. And
so who is the commissioner?
Tahsildar Port Blair Tahsil.
Tahsildar.
Port Blair Tahsil. And the last order, my lord, the defendants had made an application for repair work of the suit property. It was allowed and a direction was given to them to file a compliance report to that effect. But the case is pending for order, my lord.
You are referring order number?
Yes, my lord. My order number, my lord, order number 42, 13 September 2017. Order number 42, 13 September 2017. Typed version.
So whether writ was issued?
Yes, my lord, writ was issued.
So why you are here?
Yes, my lord, for a direction, my lord, so that I can,
Action upon whom?
upon the learned,
Tahsildar.
yes, my lord, for to dispose of a direction upon the court below to dispose of the
Yes.
matter within a period of 1 month, so that I can make my submission.
No, the court cannot dispose of the matter without report of the.
Yes, yes, my lord,
Tahsil.
for the same only,
Yes.
whether it would be time bound so that I can, the
Yes.
matter could be pursued. For 7 years, I am suffering, my lord, with the decree.
You are the plaintiff petitioner.
Plaintiff petitioner, my lord. I am for the plaintiff.
Okay,
petition.
please take down. The present petitioner is a plaintiff of a title suit being number 132 of 2010. The title suit was referred for partition and recovery of possession in respect of suit lands. The preliminary decree was passed
29 September
on 29
2016.
September 2000.
16, my lord.
2016. After such preliminary decree, the
Appointment of Tehsildar, my lord, order number 39, 11 April 2017, my lord.
Kevalam? After such preliminary decree, the Tehsildar Port Blair was appointed as a commissioner to effected the petition regarding the shares declared by the court in respect of the plaintiff. The plaintiff on 13/9/2017. Stop. The writ was handed over to the commissioner. That is the Tehsildar Port Blair. The stop. The report of the Tehsildar is yet to be received by the learned trial court. Consequently, the instant suit was stalled before the learned trial court. Stop. Now the petitioner plaintiff is before this court for necessary stroke plaintiff is before this court for necessary direction. Stop. It appears that the instant suit was filed in the year 2010.
10.
Stop. The preliminary decree was passed in the year 2016. Stop. Considering the long tendency of the instant suit, the learned civil judge senior division
Division.
Port
At Port Blair.
is directed to issue a specific direction upon the Tehsildar Port Blair, informing that the matter has been moved before this court by the plaintiff for expeditious disposal of the instant suit. Stop. Learned civil judge senior division court there is further directed to communicate the Tehsildar so that the report may be reached to the court positively within 12 weeks from the date of receipt of the instant order. The date of receipt of the order, not instant. From the date of receipt of the order. Of the order, stop. The direction of the civil judge senior division Port Blair upon the Tehsildar, coupled with a copy of the instant order. A copy of this instant order. Stop. Let a copy of this order be served upon the Learned Civil Judge Senior Division Court Blair through the registry for proper compliance on the above observation. The incident CO is disposed of.
My lord, just one prayer, my lord, and further one direction to the learned court below to dispose of the matter within a period of 4 months so that
Let the receipt.
report, very
Okay,
well, very
let the
well. I
receipt
will,
the report, otherwise how can?
very well. Obliged.
For the rest. देखी
Item number 6, CO 15 of 2023.
My lord, in this matter, my senior Mr. Rakesh Pal Govin is appearing for the petitioner, my lord. I pray that the matter may be listed on the tomorrow, my lord.
Not today.
My lord is suffering from high fever, my lord. That is the reason.
Very well, not today.
Obliged,
Item
my lord.
number 7, WPA 953 of 2023.
My lord, in this matter also my senior is appearing. Let the matter may be listed tomorrow, my lord.
Not today.
Obliged, my lord.
Item number 8, WPA 964 of 2023. This related to the grant of electricity connection and brought us dispose of certain matter from extension.
Same order may be directed.
Item number 7, I was there, sorry, I was before.
Oh, it is not. So item number 8. Date of application, 2nd of May 2023. 2nd of May 2023. Same order.
Right. Item number 9, CO 4 of 2023.
No one is there. Not today.
Item 10,
I agree with the petition.
CO 9 of 2023.
Here, your lordship.
Yes, what is this?
So this matter was referred for mediation and the mediation failed. A preliminary decree was drawn. And that was never challenged by the other side. After the final decree was drawn, they have challenged it, saying that the shares have not been defined properly and all. So when the matter came before the appellate court, on consent of both the parties appointed a commissioner to effect partition.
Very
So
well.
when the report came, there was some observation which was not acceptable by the other side. So second commissioner was appointed. And finally, the commissioner's report was there. Both of us didn't have any objection, but the learned court found that there is one a temporary structure that has not been properly defined. If there is a temporary structure, how the partition can be affected, there are certain observations by the appellate court. So I challenge that particular order because since we don't have any objection with regard to that report, but court has observed the impugned order appears at page 58. It starts from page 58. Order number 53 on 4th of January 2023. May I read it?
Yes.
Today speaks for appearance of Tehsildar Portware. Shri Ramesh Kumar Tehsildar Portware is present. He is called on dock in some clarification regarding commissioner report submitted by him on the preliminary decree passed in connection with title proof number such as that. It is clarified by the Tehsildar that the allotment was made in presence of the party and Hriday Narayan, that is the appellant herein, was not willing to accept the other share, save and accept the vacant part of the land through his temporary card shed. Though his temporary card shed falls on the portion allotted to Srimati Pooja Devi, the respondent number 1. On perusal of the report, it appears that admittedly the appellant and the heirs of Ganga Sharan, respondent number 2 to 4, are in possession of the suit property, and it is the duty of the commissioner to make the allotment of the property in such a manner that it should not cause any further complication in peaceful possession and enjoyment of property by the allottee. From the report, it appears that the suit property is measuring about 500 square meters, and the commissioner has correctly subdivided the same in 3 portions in equal share, which are proposed to be renumbered as survey number such and such respectively, and he allotted the vacant portion to the appellant bearing proposed survey number such and such, and he allotted the portion bearing proposed survey number such and such to the respondent number 1, and the temporary car shed constructed by the appellant falls on the portion of Srimati Pooja Devi. In general, the partition is effected by maintaining the present possession of the parties in the suit property, and in the instant case, the temporary car shed of Hriday Narayan falls within the allotted share of respondent number 1, which may lead to future complication. And since the principle of partition is to allow the party to possess and enjoy the property peacefully, this allotment cannot be accepted.
Okay.
So this temporary shed was never objected by the other side. Their only contention was that the commissioner, while putting the commissioner's report, has included certain excess land into their land, saying that they are in occupation of certain excess land. So that shouldn't be the report of the commissioner. That was the sole objection raised by the other side. And we did not have any objection that car shed, she didn't have any objection that car shed should not be removed. I didn't have the objection that car shed is causing obstruction in my property, nothing of that sort. But the court has exceeded the jurisdiction, saying that since there is a car shed, it can't be partitioned. Preliminary decree was never challenged. We go by the merit, then it doesn't stand, but still I wanted to solve it. That is why on consent commissioner was appointed.
So who is for the respondents?
Mother, I am for the respondent number 1. Mother, the thing is that preliminary decree never challenged because it was in our favor. I am having the copy of the preliminary decree.
Oh, okay, you just have to.
Because in that opportunity was given to the all the share, that 1/3 of the share has to be given to all the parties. So we never challenge it. It is reflected, but in the final decree, only the share of Pooja Devi was asserted and our share was not done. So we challenge that decree before the district judge. And my lord, the thing is that we have objected the report which has been submitted by the commission because he has sailed beyond that his territory. Because he was only assigned to demarcate survey number 231/5, which is the proposed survey number. But while submitting the report, he has given the report of 231/2 also, which he was not supposed to give. I have raised the objection before the learned court below because now if I am accepting this report, because he has shown that my house is standing survey number 231/2, that is in the premises of girls' school. Now, if I am going to accept this report, this will be binding upon me for entire life. I cannot challenge because they will say that you have accepted this report and this is binding upon you. So I will be evicted from the land which is actually mine, but I have shown in other premises. He should have given a report to the extent to which he was supposed to do. He was not supposed to give the. It is
That option can be very well expunged. That can be expunged with the consent of the parties as well.
No, for that.
So one report is required.
Yes.
Press report.
And that is.
But the court's obligation is not that you have exceeded your limits. Nothing of that, sort, and they never challenge that also.
Maybe, but the district court has, whenever he has assigned all the people before, and you want a fresh commissioner report.
So one thing can be done, your lordship, since my learned sister has no objection with regard to the car shed, that we can resolve it. And further direction can be given upon the lower court to ask him to give confined to only the portions which have been asked him to do. Because our problem is that certain portions.
Whether you have stated that the excess portion was allotted or the commission was done before the district judge.
With the revision application. I've submitted my objection before the meeting.
Okay.
Having a copy of that.
So you don't have any objection regarding the car set?
Madam, if that area comes within this land, my car, I will be having possession of car space. Because they have dislocated the property. They have not done the, kindly see their written objection, what they have. They have not, never raised about that. They have only said that he has exceeded his jurisdiction by including certain survey numbers which are not the part of the commission. Now they cannot change their stand by saying that now they have an objection with regard to that.
Yes.
If fresh demarcation is done, everything will be.
This will be the seventh demarcation
But
year,
it
year
is not- it is not my,
seventh demarcation. It is a never ending procedure.
and your, my
we go by
that there is 30 major area between two car shed. But the apparently she is not ready to take that area. She wants the car shed only. There is.
The temporary car shed can't be removed,
Maybe, but the thing is
and
that
which was constructed as a dependency.
they are going to feel that area, car shed. And we can push it to the extent that what she's going, she will get in the shed, it is there, but she is not ready to take accept that. In relation with process also that, this
My
thing was
mistake was that, your lordship, that I consented for a demarcation. I agreed for the commissioner. I shouldn't have. I should have argued on merit, saying that when, once the preliminary decree was not challenged, they cannot challenge it. There is a
because
specific
it
bar.
was in our favor, it was in our favor. Why I should
There
challenge
is
it?
a specific bar in the CPC.
It was in our favor.
I wanted to resolve and a consent was given. Now this is going to be seventh commissioner. I have enclosed all commissioners' report. For one or the other reason, they have been raising objection.
The
But this
commissioner
time, I was also convinced to let his portion be declared as
The
not
person
acceptable.
talking about the car shed, if she has getting the vacant position, her.
Now she cannot take a stand when she has not raised objection in the written objection.
I've
Now,
raised it.
now
I've
they are
raised that.
changing their stand by saying that they have an objection with regard
I've
to
raised
car
that,
shed.
I've located the survey number.
No, not.
But yes,
Doesn't have
I've
to-
stated, I've stated.
No, the issue is that you cannot go beyond the preliminary decree. This is the,
Yes, in reality,
so why, no, so why the partition commissioner was not acted upon the preliminary decree? He has acted upon the preliminary decree, and it appears that one card shed is within the demarcated area of the defendants. Isn't it?
That's a temporary structure.
Temporary structure.
car shed is there.
So,
My lord, the preliminary decree says that all the parties should get 1/3 share. So even I was supposed to get 1/3 share, so I accepted that. But when the final decree was drawn, only the share of Mother Devi was assigned, that her portion should be located and should be given. So I challenged that decree, final decree, because the preliminary decree, the decree is very much clear. The plaintiff to get a decree for 1/3 share of the land, the defendants are also entitled to get the same share in the suit property as mentioned in the Shulga plea. So it is in my favor also, why you should challenge it?
so what is the dispute now? The dispute now, what is the dispute now?
On
The plaintiff have not open 1/3 share, vacant 1/3 share. No, what is this? No, direction was there to the Tahsildar to reallot the share
Yes,
by meets and bounds. So what is your objection against this? Regarding the card set only?
No, her objection doesn't speak so.
No, there is specific direction regarding the reallotment of the share by meets and bounds.
Specific
My
bar in
lord, if
CPC
if the
97.
order to Leonard, this is it, if as per the last order, Leonard, this is it, that if the Tahsildar further demarcate the property, I think the matter will
It will
be.
be never ending because this is going to be a commissioner's report. Commissioner's report. I have enclosed all the commissioner's report.
That's why you are facing this problem.
No, the issue is that that has to be settled. That has to be
That is
settled.
why it is happening, because each time I am consenting that it has to be settled. Otherwise, I would have argued on merit. 97, there is a clear path. I wanted to resolve it, but it has become a never ending proceeding. When they don't raise any objection in their written objection about my car shed, and now they are changing their stand by saying that no, this will come into my portion. When the commissioner has, the Tehsildar has given a specific report. See, this is the allocation.
Okay, specific, even the London court was not satisfied with the report submitted by Tehsildar.
Now we have to see whether London court has exceeded the jurisdiction.
Tehsildar is binding upon the court.
The Tehsildar has specifically stated it is practically partitionable. That word has been used. The court has gone a step ahead, which the court shouldn't have done.
Court is not bound to admit, accept the report of Tehsildar if the court is not satisfied.
When the parties aren't consenting,
We are
the
consenting.
Tehsildar
You
is
are taken-
consenting.
The victim position of the
Court
court
can
can
exceed its jurisdiction.
which is the position of my client since time over, when he has completed the house.
No, the petitioner is before this court regarding the order of the district judge
Yes,
for the direction to reallow.
yes.
Okay, for the direction of to reallow. Because your stand is the allotment was correct.
Yes.
Your stand is allotment is correct. That is in respect of the car shed and other thing,
Yes.
temporary car shed.
The Tehsildar himself has given an opinion, it is practically partitionable. That word has been used by him. Tehsildar's report may kindly be seen.
Refer me the page.
Yes, yes, page 50. It starts from page 49. There were certain questions were framed. Inquire the property after giving notice to all the parties. Divide the properties into 3 shares. Make special note about the structure, if any, constructed on the property, mentioning their age, etc. Detailed description of the property, whether it can be partitionable or not. Value of the shares, including structure, if any. Possession of the parties in the smooth property after dividing the share. Very beautifully he has given. Schedule of the property he has given. Proceedings, he said that he has served the copy to the other side. Now coming to Commissioner's report. As per the direction of the Honorable Court, the smooth land was demarcated by the surveyor on the field on such and such date. The point wise details as sought for is submitted hereunder. Inquire the property after giving notice to all the parties. A notice by such and such has been issued to all the concerned, not concerned. Divide the property into 3 shares. Now 3 shares have been depicted. 3. Make special note about the structure, if any, constructed on the property, mentioning their age, etc. Temporary car shed measuring an area 25 square meter belongs to Sri Hiday Narayan, son of late Motilal, constructed during the year 2000, falls over the land bearing survey number 2317 by 1/2, which is the petitioner herein.
Okay, you are the petitioner.
Yes, number 2, your lordship.
Srimati Pooja Devi.
Pooja Devi. 2317/1/2 has been allocated to Pooja Devi. Now he says that 25 square meter from that survey number, measuring an area 166.65 square meter proposed in favor of Pooja Devi. Temporary car shed measuring an area 18 square meter and temporary rented house measuring an area 10 square meter belonging to Madan Lal such and such in the year 2010 falls over the land bearing survey number of Ganga Share. Detailed description of the property, whether it can be partitionable or not. The land bearing survey number 231/7 number 1, measuring an area 500 hectares, classified as house site situated in Aberdeen village under Kobla Tehsil, stands recorded in joint names of Ganga Sharan, Hriday Narayan and Pooja Devi, so and so. The suit property is partitionable. Value of the share has been given. Possession of the parties of the suit property after dividing the share. Presently, the land is under occupation of Hridaya Narayan and legal health of late Ganga Sharan. It is therefore humbly prayed that local investigation report of the suit may kindly be accepted. 25 square meter, 10 square meter, and 25 is the only problem with regard to temporary shed. Out of 1,660, 666.650 square meter, 25 is the car shed.
So it within the area of Puja Devi.
Puja Devi. Commissioner says that it is practically partitionable. And their objection is, doesn't speak that it is not so. Only their objection is some other land has been included in the partition, which they shouldn't have done it. That too in the map, not in the report. In the map, they have he has depicted. Not in the report. My only thing is, your lordship, that whether court has exceeded its jurisdiction without considering the commissioner's report. I can understand if that was not practically partitionable, a permanent structure is lying there. I can understand that. I can even understand that other side has raised objection to that effect. And look, I cannot demolish it, it's the permanent in nature. It is a consented preliminary decree. Between brothers and sisters.
The thing is that now what the commission.
Yes, what is your submission?
The thing is that now what the report has been submitted by the commissioner, the map which he has given. If I am going to accept it, it will be, I have to bound by this, because you say you have accepted it and your land is in the school. So I will be bound by this report. I cannot go further. Once you have accepted, you cannot say no, it is not the report. I have to challenge this map. If at all anything, if they're getting order also, because I cannot accept this. He was not bound to give the report of 751
No, whether you have filed any objection?
As far in my objection, I've stated that he has dislocated the land. Because he has dislocated the land, so my land has been shown in girls' school. I've filed the written objection to that effect. That house of Sri Narayan.
So your objection in respect of only map.
Map. And the thing is that he has dislocated the land of dislocated survey number 231/1. He has moved the land to north direction. So I.
Okay, in respect of map only, not in the report.
No, there isn't any objection with regard to report. Only map that he has depicted that she is in
Yes.
possession of certain area.
Yes, in report is not there, but in map he has shown everything. And obviously the demarcation will be done as per
There
that.
can be an observation that we cannot travel beyond the direction given
But
by
my
the court.
thing is that he has dislocated the position of survey number 231/1. Because of that, now the demarcation is there, it will be as per this map, and this land will be dislocated, and I will be fall short of my land in survey number 231/2.
So that they can raise a separate proceeding if they wish. My contention is, can the court exceed the jurisdiction when the
If the matter can be solved in this, why separate proceeding?
it is never ending, it's a seventh, again a report will come, again they will discontinue with that, they will not be agreeable
It
for
can be
anything.
solved in this matter.
No, you don't have any objection against the report.
The report does not say anything like that, but when you go through the map, everything is.
Okay, I understand. The Tehsildar has submitted a map along with the report, which is,
Report. We cannot say it is the.
I understand. You have stated that the map contain excess area of
231/2. That was not at all the land that was for which he was supposed to submit report.
That is your objection.
Original suit started in 2007. The partition suit is taking so much. Yeah. Years already passed.
No, the non-suit property cannot be included in the suit property.
Yes,
That is the view.
but there is an observation, that can be relied by my learned sister. The court has observed that which is not the part of the partition suit. Why have you included it? That portion can be expanded. And she can take advantage of the same.
It will be a problem later.
No,
It will be a problem.
it is authenticated by a high court, order of the high court.
And I have raised objection that he has dislocated the land. For that only my land.
No. Your objection in respect of only map. Map has prepared erroneously.
Around this.
That is your objection.
But it is a part of.
No. That is maybe part of the report. Fresh map can be directed to be prepared. That is the issue. Fresh map can be directed to be prepared.
My objection, in my objection, I have stated that he has dislocated the.
He has prepared a report on the basis of preliminary decree, which you have not challenged. Okay, so it appears that the report in respect of the preliminary decree is correct, but he has prepared a map which has taken some excess land. That is your objection. That cannot be. That is illegal. He cannot prepare a map on the basis of a report of a preliminary decree, which is including some other non-suit properties. That is your objection. That is well accepted. That can be directed only. The report may be there, and on the basis of that report, a fresh map may be prepared by the Tahsildar.
My lord, without proper demarcation, map can be prepared.
That is the duty of the Tahsildar. He shall demarcate it properly and prepare the map. Okay. Okay, please take down. Instead, read petition was preferred against an order dated 4th of January 2023, passed by the learned district judge, directing the Tahsildar Port Blair to re-alert the share of the parties by meets and bounds, keeping in view the present position of the parties on the suit property. Stop. As per the learned advocate for the petitioner submits that the report of the Tahsildar is in respect of a preliminary decree passed by the learned trial judge. Stop. The preliminary decree was never challenged by the defendants. Stop. By virtue of the preliminary decree, the suit property was partitioned by meets and bounds by the report of the Tahsildar. Meets and bounds. METES. Bits and bounds. Bounds, full stop. Bits and bounds. The Tahsildar has submitted the report. And the report is in conformity with the preliminary decree. Stop. The order of the Lane district judge regarding reallot the share is a futile exercise by which the present petitioner would be suffer irreparable loss and injury. Stop. The suit for partition watch is pending since 2007. So at this juncture, 2007. Stop. If the said pardon. If the said property was again partitioned, the plaintiffs will suffer irreparable loss and injury. We prayed for setting aside the order passed by the learned tribunal, impugn order, impugn order passed by the learned district judge. Stop. The defendants opposite parties raise objection on the ground that the Tahsildar has prepared a map along with the report, which included some non-suit plot lines, some non-suit properties. That is why the order of reallotment and share by the Tahsildar is required. Stop. In considering the impugn order passed by the learned district judge, it appears that order passed by the learned district judge, it appears that the learned district judge has perused the report wherein a temporary car shed falls on the portion of car shed falls on the portion allotted to Srimati Pooja Devi. The district judge is of view that the said temporary structure may raise future complications. Stop. That is why the order of reallotment was passed. In considering the report of the Tahsildar, it appears to me that the reports of the commissioner has demarcated the share of the parties correctly, and temporary car shed was measured an area of 25 square meters. Belong to Sri Hidaya Narayan. Who is Hidaya Narayan?
He's the appellate.
Belong to the appellant. Sri Hidaya Narayan belong to the appellant. In bracket appellant. Stop. The objection raised by the respondent hearing regarding the inclusion of some non-suit plot loss appears to be justified in perusing the map appended with the report itself. Stop. The temporary card set, which falls within the allotted area of Srimati Pooja Devi, of Sri Pooja Devi, is not in the matter of objection. However, it is true, next further. However, it is true that the partition commissioner must confine the act of partition within the suit property. Stop. Within the suit property. Stop. It appears that the though the report of the commissioner is quite correct, but the map appears to be defective, which includes some non-suit properties. Which includes some non-suit properties. Stop. Thus, the order of the learned district judge regarding reallotment appears to be not justified in the actual matrix of this case. Not justified in the factual matrix of this case. Considering the same, the impugned order dated 4th of January 2023 passed by the learned district judge is set aside. Stop. The commissioner, that is the Tahsildar Port Blair, is directed to prepare a fresh map on the basis of the report which was submitted by him on
12th of February 2020.
this report on, which was prepared by him on, not submitted, prepared by him on 12th of February 2022. Fresh map course.
Directed to prepare a face map on the basis of the report, which was prepared by him on 12th February.
It is specifically directed to the Tahsildar that he must submit, he must prepare the map only in respect of the suit property. Only in respect of the suit properties. Stop. The Tahsildar is further directed to submit the map before the learned district judge. As early as possible, more specifically within December 2026. Let the report, let the map be submitted on the above jurisdiction. No.
This is what.
Okay. Let the instant CO is disposed of on the above observations. Have you filed any affidavit in opposition like that? Have you used the affidavit in opposition? No.
She has.
Okay. As the affidavit in opposition is not used, the allegations made in the petition are not deemed to be are not deemed to have been admitted.
Much obliged.
Okay. Yes, Mr. Khan, anything?
There was the next 12 number was dismissed for default, right for restoration. I was once in mainland. Second time, and other part I was for other court. I for restoration. My personal ground, I did not have to.
Have you served?
Original application was also not served. So it is to be restored, then I will serve the notice of the main.
I understand, but I have to heard the matter.
So when it is restored, I will serve upon the other side. So CO was also not served.
You serve the CO.
Yes.
It is item number 12.
Well, can one of 2020. Order date is 21st June 2020.
Where is the can? Answer them. Please take down. Reference can 1 of 2022. Stop. Can 1 of 2022. This is an application for recalling of the, this is an application for recalling of the order dated 21/6/2022 passed by this court. Stop. Not the learned advocate. The learned advocate was engaged in another court, thus the instant WPA was dismissed. No, WPA
12.
no. Yes, CO 9 of 2022 was dismissed for default. Stop. Thus, the CO 9 of 2022. 9 of 2022, this is for default. Considering the submission, the also considering submission and considering the submission and also considering the fact that the learned advocate for the petitioner has the personal ground, thus has the personal ground, for not appearing before the learned court, before this court. Thus, the order dated June 21, 2022 is recalled. Stop. The CO 9 of 2022 is restored to its original file and number. Stop. The petitioner is directed to serve upon the respondent regarding the fact that the CO has been restored to its original file and number, and it shall appear in the list, in the monthly list of November. It shall appear in the list, in the monthly list of November. Okay, available next time.
Lordship, item number 13, same footing, Your Lordship, dismissed for default, Your Lordship. 13. I've served the copy to the government respondent, Lordship, and I was asked to serve the copy to the private respondent. The section 5 application was there.
Let me contract for them and this is
Many restoration के लिए था.
चलिए
नहीं इसको सर्विस करने बोले.
This is can number 1.
Yes, Your Lordship. Along with Your Lordship, section 5 application was there. I was asked by the honorable court to serve the copy upon the private respondent. That has done, Your Lordship.
only 20 days, 28 days of delay, your lordship, it's in personal ground.
Have you served?
Yes, your lordship, I'll serve, your lordship. Long back on 8th August 2023, your lordship.
So the can 1 is the restoration.
Along
and
with
can 2 is the
section 5, your lordship.
section 5.
Same similar order may pass through so that I can WPA 100 of 2022, your lordship.
Please take down.
But I am for the
Government.
authorities, government.
Okay. You give me your names. Reference can 1 and can 2 of 2022. Are the learned advocates? Stop. The delay in preferring the instant
28 days, your lordship.
application being can. No. Kata. Are the learned advocate? The delay of 20 days.
28, your lordship.
20 days. Please count down. Stop. It appears that the WPA
100, your lordship.
100 of 2022 was dismissed for default by the order of this court dated June 21, 2022. Stop. Learned advocate for the petitioner submits that he was engaged in another court, so he could not appear on call. Considering the submission, the this is can 2.
2, your lordship.
Then can 2 is disposed of with a direction that the order passed by this court dated June 21, 2022 is hereby recalled. The WPA 100 of 2022 is restored to its original file number. The petition is directed to serve upon the
Private response. Sole
private respondents
private response.
as well as the state,
Yes, your lordship.
as well as the state,
Yes, your lordship.
to the fact that the WPA 100 of 2022 has been restored to its original file number and restored to its original file number, and it shall appear in the list of next level.
Obliged, your lordship. Deeply obliged.